We've reached episode 20 of the BoormanLawyers Court Reports, and in this episode we take a look at a low-range drink driving offence that we appeared at Waverley Local Court, where we achieved a Section 10 dismissal.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. Niggas say it ain't no way. I ain't never listened, kept them at a distance. This is for the ones who ain't afraid. And this is more than a paper chase. I wonder who else can say the same.
Hi, welcome to BoormanLawyers. My name's Josh Boorman. I'm just standing here out the front of Waverley Local Court in the eastern suburbs of Sydney, just up the road from Bondi Junction. I've just appeared today on a low-range drink driving offence where my client was charged with a blood alcohol reading of .077. In relation to the actual incident itself, there were some quite extenuating circumstances which occurred. Basically, on the night of the offence, my client and her boyfriend had been to dinner at a local pub. They'd then walked back to where my client's boyfriend lives, a short distance down the road. Over dinner, my client admits to consuming 3 full-strength beers, which equated to about 1.3, 1.4 standard drinks each schooner of beer. And this was within a period of about 2 hours. They then walked back to where my client's boyfriend lived, a short distance down the road, and along the way, on the walk home, they ended up getting into quite a significant argument. When they reached the unit where my client's boyfriend lived, the argument erupted into quite a nasty situation. To make this matter a little bit more unusual, my client's boyfriend is profoundly deaf and they communicate by way of sign language. So it was a bit more of an unusual situation. There wasn't a lot of screaming or yelling going on, but a lot of non-verbal communication going on in quite a nasty and angry way. Neighbours witnessed my client and her boyfriend arguing out the front of the complex, and they called police because they weren't really sure what was happening, but they knew something nasty was going on. At one point, my client's boyfriend snatched her purse and her phone out of her hands and threatened not to give it back. And my client at that point felt quite intimidated. So she got her car keys. She jumped into her car, which was parked outside of the complex, and she started the engine with the intention of driving a short distance down the street to sleep in the car for the night. Her train of thought at the time was to simply get away from her boyfriend, as she did feel somewhat intimidated. Her boyfriend then jumped on the bonnet of the car in a further act of intimidation. She then drove the car forward approximately 3 or 4 metres. He slid off the bonnet, fell onto the ground, didn't sustain any injuries, but hopped back up and started arguing with her while she was in the car. She got out of the car, make sure she was okay, and she took off on foot, ran away from him to get away from the situation. He then went back into his unit. She returned back to the vehicle, sat in the car. She was emotionally upset, distressed, and she was crying uncontrollably. When the police came, they breath tested her, and they ended up charging her with low-range drink driving with a blood alcohol reading of .077. So obviously the facts in relation to this particular incident were quite unusual. There were some extenuating circumstances involved, and certainly my client has a pretty good traffic record, certainly nothing on her record of this nature, and it just showed that this particular incident was fueled by emotions, and it wasn't how my client would usually conduct herself on the road. What's more, she had only moved the car a very short distance, and these issues really needed to be explained and played out to the court in a fair amount of detail. So we did that. We indicated to the court that my client had completed the traffic offenders program. She was remorseful and contrite over the actions that she had taken on the night. We also got her to put in place a strong letter of apology outlining exactly what had happened that night. Her deep remorse over her actions, the lessons that she had taken away from the traffic offenders program. We also tendered to the court a statement from her boyfriend, also confirming that he felt partly responsible for the actions that she did take that night, since he did act in a regrettable and somewhat intimidating manner towards her, to somewhat cause her to jump into the car to begin with. We also had a letter from my client's Australian Sign Language tutor to confirm that she is in the process of becoming an Auslan interpreter or an Australian Sign Language interpreter, and this just shows that she is a person of relatively good character. She does give a lot back to the community and those less fortunate. within the community. We also got another letter from her employer just to confirm her employment and her need to remain conviction-free, since she does require to maintain a working with children certificate, and any person who needs to maintain a working with children certificate needs to remain conviction-free. So that was one point that we expressed to the court, that any criminal conviction could cause problems in her ability to continue to work with children and her ability to continue in her current employment. So with all that, we explained that to the court, and we presented all that material, and the magistrate was very receptive to what we had to say, and especially the material that we presented. We did seek that our client be dealt with under the provisions of Section 10(1)(b), putting our client on a good behaviour bond for a period of time. However, under Section 10, that means that our client would not be criminally convicted, would not have her licence disqualified, and would not receive a financial penalty. And the magistrate agreed with us in relation to our submission of a Section 10. He put our client on a good behaviour bond for 6 months under Section 10, and that was the end of the matter. So our client was extremely thankful that she was able to maintain her driver's licence, maintain a conviction-free record, and move forward past this unfortunate incident. So guys, if you've found yourself on the wrong side of the law, made a mistake, as you can see, this case was quite different. There were some unusual circumstances involved, and every drink driving case is different in relation to the facts. So if you found yourself in such a situation, then feel free to give me a call on 1300 941 900, or alternatively go along to our website, which is BoormanLawyers, BOORMAN lawyers.com.au. What we've done there is we've tried to create a bit of an information hub surrounding traffic laws in New South Wales, in relation and information there surrounding offences, laws, penalties, statistics. There's videos, court reports like this one that you can view, read, watch up on to make yourself familiar with the particular situation that you might find yourself in. But by all means, feel free to give me a call to have a free first telephone consult in relation to your matter, 1300 941 900, and we can see what we can do for you. Thanks for tuning in today, guys. Cheers.